Good day, Crime Talk aficionados. It's Monday and the start of December. What's going on? First, the trial of Bryan Walshe has begun. How did Anna die? A medical event or murder? Bryan Kohberger, yes, we have no bananas. Pretrial motions in the Luigi Mangione case. The South Carolina Supreme Court schedules a hearing for Alex Murdaugh's murder conviction appeal. An Ohio man is accused of one of the worst crimes. A little vigilante assault follows release of a Brooklyn man accused in a series of racial spitting attacks. We've got this day in legal history, our quote of the day, and of course, our dumb criminal. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, and make sure you hit that bell for notifications of when we go live or put up new content. And remember, you can check us out on any of your favorite podcasting apps. Now, you may say, Scott, that is a great sweatshirt. Did you wear that to court today because it's cold? No. I wore it because it just looks good. And guess what? You can get the Crime Talk limited edition merch in various colors and various sizes, so go check them out. Also, let me remind you to go to crimetalksearch.com, sign up for that background subscription service today. When you do, you'll be able to do a background search on as many people as you desire here in the United States, and you will get information that sometimes will just blow your mind about somebody. We were doing this on somebody that we knew, found out some stuff. Yeah, interesting. Not going to get into the details, but I'm telling you, you're going to find out something you didn't know. Go to crimetalksearch.com and sign up for that background subscription service today. All right, let's go ahead and open the record for Monday, December 1st, 2025. First, the Bryan Walshe case. That's right. The case of Bryan Walshe centers around the Massachusetts man charged with the murder of his wife, Anna Walshe, who disappeared on January 1st of 2023. Now, remember, Anna was 39 at the time, and she was a real estate executive based in Washington, D.C., who commuted between the capital and their family home in Massachusetts. The couple had 3 young children. No body has been recovered, and no autopsy obviously has been performed, complicating the prosecutor's case. Now, Walshe, who was under house arrest at the time awaiting sentencing in an unrelated federal art fraud conviction, that's right, he was selling fake Andy Warhol paintings, faces a single count of first-degree murder. Now, what do we know that happened? On New Year's Eve, 2022, a family friend visited the Walshe home for dinner, and they observed Anna appearing healthy and that the family, well, for lack of a better term, seemed normal. And then on early January 1st, 2023, Walshe reported Anna leaving for a work emergency in D.C. about 5 or 6 a.m. in the morning. She was last seen wearing black pantsuit, boots, and a long coat. Surveillance footage captured Walshe purchasing cleaning supplies, mops, tarps, bleach, at a Home Depot in Canton, Massachusetts around 9:30 a.m., followed by additional items like a hacksaw and protective gear, for all those do-it-yourself body dismembering things, I guess, allegedly. Anyway, cell phone and browser data from Walshe's devices, including his son's iPad, revealed searches such as how long before a body starts to smell, 10 ways to dispose of a dead body, if you really need to, can you be charged with murder without a body, and the best date for a divorce conducted shortly after her disappearance. I'm sure it's all just coincidence. Anyway, Walshe misled investigators by claiming that Anna drove to D.C. after missing a flight, providing false details about her itinerary, and he did not contact her employer until days later. We also have evidence recovered from a dumpster near Walshe's mother's home in Swampscott, including bags containing a hatchet, a hacksaw with some bone fragment, some bloody towels, a Tyvek suit, cleaning agents, and Anna's Prada purse, boots matching her description, an Hermes watch, and her COVID-19 vaccination card, all bearing traces of her DNA. Well, there was also some blood was detected inside Walshe's Volvo SUV. Now, prosecutors allege a motive tied to Anna's extramarital affair with a real estate developer by the name of Bryan Kohberger, her $2.7 million life insurance policy, naming Walshe as beneficiary, and her plans to relocate with the children to D.C. amid this marital discourse. Now, Walshe was arrested on January 8th after extensive searches of dumpsters and landfills across eastern Massachusetts, yielding the aforementioned items, but no body. Walshe was indicted back in February of 2023 on first-degree murder, improper conveyance of a human body, and misleading a police investigation. And then on November 18th, of this year, the first day of jury selection, he pled guilty to the two lesser charges without a plea deal, facing potential additional sentencing, but proceeding to trial solely on the first-degree murder charge. So, as of today, the trial is in its initial phase there at the Norfolk Superior Court in Dedham, Massachusetts, presided over by Judge Diana Frenier. Jury selection concluded last week with a panel of 12 jurors, and alternates are seated as well. Opening statements were delivered this morning, marking the start of the evidentiary phase. The trial is expected to last 2 to 3 weeks, with prosecutors anticipating calling 20 to 25 witnesses, including Massachusetts State Police investigators. Notably, Sergeant Michael Proctor, recently fired from the Karen Reed case, and defense attorney Kelly Porges and Larry Tipton represent Walshe, while the assistant district attorney Gregory Connor leads the prosecution. So, pre-trial, what happened? On September 11th of this year, a stabbing incident in the jail delayed the trial by several weeks. Walshe recovered and then was deemed competent. On November 17th of this year, final pretrial conferences addressed issues like a private investigator hired by Walshe's mother regarding Anna's alleged infidelity. And Walshe, already serving over 3 years for the art fraud, faces life imprisonment without the possibility of parole if he is in fact convicted of the first-degree murder charge. Sentencing on the guilty pleas is obviously going to be done after the trial. Now, no further delays are reported, and proceedings are being live streamed, and we're bringing them to you right here. So what do we know about the opening statements that were delivered this morning? Let's just say there were starkly different narratives of what allegedly took place. Now, prosecutor Gregory Connor outlined a premeditated killing driven by jealousy and financial gain, emphasizing circumstantial and digital evidence. Defense attorney Larry Tipton conceded Walshe's lies to the police, but argued an accidental death, challenging the motive and forensic links. Now, the statement by Gregory Connor, the prosecutor, a meticulous investigation revealed Walshe's calculated actions post-disappearance, humanizing Anna as a vibrant professional and devoted mother. He detailed the timeline, Anna's last confirmed sighting at home, Walshe's immediate suspicious purchases and searches, for example, the dismemberment methods, body disposal, and his evasive interviews where he denied knowledge of her affair despite cell phone data showing searches for Bryan Kohberger on December 25th in 2022. Recovered items as damning, example, DNA-laden clothing and tools in the dumpster, arguing they prove Walshe's brutality and how he brutally murdered Anna to prevent her departure with the children and to secure the insurance proceeds. He stressed the absence of any DC travel evidence and Walshe's behavior as indicative of guilt, stating this is not a mystery. The evidence will show Bryan Walshe killed his wife and tried to erase her from existence. Now, the statement lasted about 25 minutes. Then the defense got up. Larry Tipton acknowledged Walshe's guilty pleas and lied to investigators as mistakes born of panic, but firmly denied murder, claiming Anna died from a sudden, unexplained death, possibly a medical event like a fall or overdose. While alone preparing to leave for D.C. He portrayed the couple's finances as stable. Example, Walshe's mother covering rent, access to investment properties, dismissing infidelity or insurance as motives as nothing, no history of domestic, and noting no history of domestic violence. Tipton attacked the evidence as circumstantial, searches as generic curiosity amid Walshe's true crime interest, dumpster items as unrelated household waste, and DNA traces as inconclusive without a body. He urged jurors to focus on reasonable doubt, stating there were no financial problems here. Bryan panicked and lied, but he did not kill Anna. The statement emphasizes that the prosecution's burden in a no-body case, which lasted about 20 minutes. Now, the trial resumes tomorrow with witness testimony, focusing initially on the timeline and digital forensics. We told you last week when Walshe pled guilty to the less serious charges that he's going to have to go with some sort of defense of, it was an accident or she died naturally. And then I just panicked and decided to allegedly dismember his wife and spread her pieces all around. So it kind of puts the defense in a bad spot because the defense is going to want to know what happened. You pled guilty to chopping her up and moving the remains. Why didn't you just call the police? I get it. Defense had a tough call to make, but I'm not sure it really helps in the long run. I'm a firm believer, hey, if you're going to charge me with, 3 counts, why am I going to plead guilty to 2? Prosecution's going to say he pled guilty to 2. He just doesn't want to go do life in prison, ladies and gentlemen. Obviously, they can't make that argument directly, but that's the reality of it. Next, Bryan Kohberger. Yes, we have no bananas. That's right. Bryan Kohberger, currently housed at the Idaho Maximum Security Institution, has submitted a formal complaint regarding the bananas provided as part of prison meals, according to statements made by retired homicide detective Chris McDonough. Now, McDonough, who is affiliated with the Cold Case Foundation, indicated that Kohberger objected to the specific type of bananas being served, stating they were not the kind that he likes. Poof. Well, stop everything. Bryan Kohberger doesn't like the bananas being served in prison. Hey, anyway, the complaint reportedly centers on either bruises on the fruit or a preference for a particular variety, though the exact details were not specified. Well, the Idaho Department of Corrections has not publicly confirmed the variety of the conditions of their bananas distributed to inmates, nor has it disclosed whether Kohberger's request requires a specific type or quality of banana. Now, this complaint is one of several submitted by Kohberger in recent months concerning his conditions of confinement. Previous grievances included allegations of threats and harassment from other inmates, claims that he did not receive full meal portions, and a request to be transferred to a different housing unit within the facility. Why? Because the inmates were harassing him by keeping him up all night. Now, according to the latest reports, prison authorities have reportedly instructed Kohberger to accept the standard provisions. Now, for those who don't know, Kohberger is serving 4 consecutive life sentences without the possibility of parole at the Idaho Maximum Security Institution following his conviction for the 2022 stabbing deaths of 4 University of Idaho students. Now, the phrase, "Yes, we have no bananas," for those who aren't familiar with it, originated in 1922 from a song, "Yes, We Have No Bananas," written by Frank Silver. And the song humorously depicts a fruit vendor who responds affirmatively to every inquiry except when asked about bananas, which were unavailable. It became a major hit in the 20s, reflecting a real banana shortage due to a blight in Central America, and has since entered popular culture as a comedic catchphrase. Yes, Bryan Kohberger, we have no bananas. Next, pretrial motions in the Luigi Mangione case. What have we told you all the time, ladies and gentlemen? The motions hearing are the most important part of any case. It decides what evidence is going to come in. Was it obtained illegally or legally? And it's really a watershed moment in any case. And here, what do we have? He's asking for the evidence, his backpack, to be suppressed. Why? Because it has its journal, i.e. confessions. Oh, it has the gun. It has the silencer. Yes, those are all bad things. You can always look to the motions filed by the defense because they're trying to make the bad evidence go away or limit its admissibility or limit how it can be used in court. So obviously the defense thinks these are bad things for the defense case. Hence the reason they're trying to get them suppressed. So as the first anniversary of the fatal shooting of the United Healthcare executive Brian Thompson approaches, Luigi Mangione, the 27-year-old Ivy League alum accused of the crime, returned to the Manhattan Supreme Court on this morning for a series of pretrial motions hearings. These proceedings, expected to span the week, represent a pivotal phase in Mangione's state-level prosecution for second-degree murder and criminal possession of a weapon. Now, hey, he ditched his prison attire for a tailored suit, and he appeared quite composed amid a visible show of support from admirers outside the courthouse, underscoring these cases' transformation into a cultural flashpoint. So, what's going to take place? The motions hearing serves as a foundational element of the American criminal justice system, designed to resolve evidentiary and procedural disputes before a trial commences. Now, these motions hearings allow both the prosecution and the defense to present argument to the judge, here, State Supreme Court Justice Gregory Caro, regarding the admissibility of evidence, the scope of the witness's testimony, and other matters that could influence the fairness of the proceedings. By addressing such issues in advance, the court aims to prevent the introduction of improperly obtained or prejudicial material, thereby safeguarding the defendant's constitutional rights under the 4th, 5th, and 14th Amendments, while ensuring that the jury receives only relevant, legally admissible, reliable evidence. Now, obviously, in high-profile cases like Mangione's, these hearings can dramatically alter the trial's trajectory. Rulings on motions to suppress evidence, for instance, may exclude key items that link a defendant to the alleged offense, potentially weakening the prosecution's case or even prompting plea negotiations. Now, over the coming days, Justice Caro is anticipated to evaluate testimony from more than 20 witnesses, including law enforcement officers involved in Mangione's arrest, to determine the fate of the contested materials. Now, the meticulous review process not only streamlines the trial, but also upholds the principle of due process, ensuring that convictions rest on untainted evidence. So, what is the key motion under consideration here? Well, Mangione's defense team, led by experienced counsel, has filed several motions targeting evidence recovered during his December 2024 arrest at the McDonald's in Altoona, Pennsylvania, following the nationwide manhunt. Now, central to these efforts is a motion to suppress physical items seized from Mangione's backpack, including the 9mm handgun, allegedly matching the weapon used in Thompson's shooting, a 3D printed silencer, and electronic devices. Now, the prosecutors contend that these items directly connect Mangione to the crime scene, where surveillance footage captured a masked assailant firing at Thompson from behind as he was en route to an investors conference. Complementing this, the defense seeks to exclude Mangione's handwritten journal, which authorities described as containing explicit expressions of intent to target a health insurance executive. Entries reportedly reference admiration for historical figures like Ted Kaczynski and decry the greed-fueled practice of the insurance industry, framing the act as justified response to systemic inequalities. Additionally, the motion challenges the admissibility of certain pre-arrest statements, such as Mangione's alleged use of a false name during his initial questioning. Now, a secondary motion addresses proposed prosecution witnesses, arguing that individuals who identified Mangione based solely on post-incident surveillance reviews rather than direct observations of the shooting should be barred from in-court identification. Now, this challenge invokes concerns over reliability and suggestibility in eyewitness testimony. Now, while these motions pertain exclusively to the New York State charges, Mangione's attorneys have signaled intentions to pursue parallel suppressions in his federal case as well, which includes counts of murder via firearm, stalking, and weapon offenses. So what is the argument that everybody's clashing about? Well, the defense's position hinges on allegations of procedural violations during the Altoona arrest, asserting that the irregularities rendered the evidence fruit of the poisonous tree, which is a legal doctrine excluding unlawfully obtained evidence and their derivatives. And attorneys argue that the Pennsylvania officers conducted a warrantless search of the backpack under the pretext of safety concerns, with body camera footage purportedly showing an officer inspecting contents while citing a need to rule out explosives. This, they claim, constitutes an unjustified intrusion absent exigent circumstances or probable cause, breaching the Fourth Amendment protection against unreasonable searches and seizure. Furthermore, the defense contends that interrogative questionings posed prior to his Miranda advisement required advisement of rights to silence and counsel, and that violates his Mangione's Fifth Amendment rights, tainting statements like the false name that he was given. On witness identification, counsel emphasized the absence of contemporaneous eyewitness accounts, warning that reliance on mediated footage risks misidentification and undermines trial integrity. Collectively, these arguments portray the arrest as a rushed operation marred by overreach, potentially depriving Mangione of a fair trial and warranting evidentiary exclusions to deter future police misconduct. Prosecutors from the Manhattan District Attorney's Office countered that the search was a lawful protective measure amid heightened alert for an armed fugitive, justified by officer safety protocols during a high-risk apprehension. They invoked the inevitable discovery rule, arguing that the backpack's contents would have surfaced routinely during a post-arrest inventory process, independent of any initial scrutiny. Regardless of Miranda compliance, officials maintained that custodial interrogation had not yet begun when the false name was provided, rendering warnings unnecessary at that juncture. Subsequent statements, they affirm, were properly administered post-Miranda. Now, on the journal and devices, the prosecution underscored their probative value in establishing motive and premeditation, quoting passages that align with ammunition markings at the scene, the delay, deny, and depose that he allegedly scribbled onto the ammunition, echoing industry critiques. Now, for witnesses, they defend identification as corroborated by forensics and circumstantial evidence, arguing that surveillance-based recognition meet evidentiary standards when unchallenged by bias or error. And in federal filings, which may inform state arguments, prosecutors have dismissed broader claims of political prejudice stemming from the public remarks from President Donald Trump and Attorney General Pam Bondi as extraneous to the prosecution team, citing judicial presumptions of impartiality absent demonstrable harm to the jury pool. So what does this mean? This hearing unfolds against obviously the backdrop of intense public scrutiny, with Mangione's detention at the Metropolitan Detention Center in Brooklyn drawing daily correspondence from his supporters who view him as an emblem of resistance against the health care inequalities. The timing, mere days before December 4th, amplifies the proceedings. Resonance and the Thompson's death continues to fuel debates on corporate accountability. Now, Justice Caro's forthcoming decision could reshape the narrative. Suppression of the gun and the journal might compel prosecutions to lean more heavily on ballistic matches and video analysis, while denials would fortify their narratives of deliberate intent. Regardless of the outcome, the state trial remains unscheduled, with federal matters slated for January 9th of 2026. Now, this little legal saga continues. It exemplifies the delicate equilibrium between the public safety imperative and individual liberties, a tension that lies at the heart of the motion now before the court. And let me tell you, ladies and gentlemen, I've said this, we knew this. They filed this motion back in the Altoona, Pennsylvania case, where Mangione was charged with false information and possession of the weapon, things like that. Ultimately, that case has basically been held in abeyance. But if an officer has reason to believe to come up to you and ask you, hey, what's your name? Can I get your ID? You probably got to give it. And at that point, they determine, hey, this is Mangione. At that point, they're like, hey, this guy's wanted for murder. They're going to be able to cuff him even during the detention process, being detained for officer safety concerns. Now, depending on where that bag is, the cops will usually be able to claim some reason. Oh, that bag was near him. We believed he's armed and dangerous. We were, for officer safety concerns, going to try to make sure there was nothing there that could harm the officers or anybody else. Courts love the officer safety exception to the warrant requirement because who doesn't want to keep the police safe, right? And then they're going to say, well, even if it wasn't officer safety, which I'm telling you, 99% of the time the judges go along with this, then it's like, hey, it's inevitable discovery. We found out who he was. We arrested him. We're going to take his property. And when we get back to the police station, it's inevitable that we were going to find this anyway because we were going to inventory the contents of his bag so that we don't get accused of stealing his property and we have a final accounting of it. So we would have found it anyway, Judge, so it doesn't matter. Now, if this was in a jurisdiction where I normally practice in the great state of Colorado, this would be a flat out loser. But given the dynamics of this case, given the fact that it's New York, where sometimes the judges seem to go a little rogue, heck, Luigi could have a chance, just like that scene from Dumb and Dumber. So what you're telling me is there's a chance, right? Yeah, possibly. A slim chance. If I was a betting man, I'd say slim chance, but this is the defense doing what they have to do. They're creating an appellate record. We'll see what happens. Obviously, we'll bring it to you when it does. Next, the South Carolina Supreme Court sets oral arguments in the Alec Murdaugh case. That's right. Alec Murdaugh, the former South Carolina attorney convicted back in March of 2023 for killing his wife, Margaret Maggie Murdaugh, and their younger son, Paul Murdaugh, is seeking to have his convictions overturned and a new trial ordered. So, on June 7th of 2021, the shootings occurred at the family's extensive hunting estate known as Moselle there in Colleton County. And I'll be honest with you, when that thing came for sale, I would have bought that place in a heartbeat if I had the funds to buy that. That place is gorgeous. Anyway, following a 6-week trial that drew national attention, a jury found Murdaugh guilty on 2 counts of murder and 2 counts of possession of a weapon during the commission of a violent crime. He was subsequently sentenced to 2 consecutive life terms without the possibility of parole. And in his appeal, Murdaugh's legal team contends that the original trial was tainted by multiple irregularities, including the admissions of allegedly prejudicial financial crime evidence, the absence of direct physical evidence linking him to the shooting, and claims of improper influence on the jury by then Colleton County Clerk of the Court, Rebecca Becky Hill. Now, Hill, who oversaw the court operations during the 2023 trial, faces separate felony charges herself that include perjury, obstruction of justice, and misconduct in public office. Prosecutors allege that she improperly granted media access to sealed exhibits and used her position to advance sales of a book she co-authored about the case. Now, Murdaugh's attorneys have further alleged that Hill made inappropriate remarks to jurors that conveyed the impressions that Alec Murdaugh was in fact guilty. A post-conviction evidentiary hearing presided over by a retired Chief Justice of the South Carolina Supreme Court, Justice Jean Toll, in January of 2024, resulted in the denial of Murdaugh's initial motion for a new trial. Justice Toll characterized Hill's conduct as ill-advised, but concluded that the evidence presented didn't establish sufficient grounds to vacate the verdicts. Now, the upcoming Supreme Court proceedings represents Murdaugh's direct appeal of his murder convictions. Now, regardless of the outcome, Murdaugh will remain incarcerated for decades to come because he's pled guilty in 2024 to dozens of state financial crimes for which he received a 40-year prison sentence. Now, the February 2026 hearing will mark the latest chapter in the legal saga that has continued to captivate the public and, me as well, since the murders were first reported back in 2021. Now, we've said this all along. I think Alec Murdaugh is guilty. I think a jury properly found him guilty of the death of his wife and son. But do I think he got a fair trial? That, I think, is where I have to say, I think Alec Murdaugh should probably get a new trial. All right. Should some of the financial information that Alec Murdaugh discussed, saying, yes, I stole it, should some of that come in? Yes. But I think the judge allowed too much of it in, and it turned it in literally to, well, he lied about all this other stuff, and we're here to focus on the murder case. So that issue alone, the 404B evidence, and remember, ladies and gentlemen, if the prosecution has to rely on 404B evidence, it means they have a weak case. And obviously, some of that would be relevant, that there were some financial irregularities going on in Alec Murdaugh's life, and therefore there's of limited relevance. But when it took up a week of testimony, I think it went just a little too far. And as it relates to the clerk, once again, the clerk shouldn't have been involved. This is why I do not understand why anyone in public office should be able to write a book or do anything. I don't care what level of government you're at. If you want to go be in the public, the public sector, be a judge, be a clerk, be a legislator, whatever, city councilwoman, that should be your job. You shouldn't have to be permitted to have side hustles. It flabbergasts me. The members of Congress, they all have their own podcasts. They all have, they're writing books. They're getting paid to lecture. Supreme Court justices getting paid to go do lectures and write books. No, you want to make that money? You do it when you leave public office. But that's just me. All right. So I think Alec Murdaugh guilty, but deserves a second trial. And if it does, well, we'll be there for it. Next on the docket, an Ohio man faces nearly 20 charges in some of the worst cases of the worst. Now, let me tell you, ladies and gentlemen, I literally just finished one of these cases, and they truly are the worst of the worst. All right, let me explain. So a 50-year-old resident of Cleves, Ohio, hopefully I'm pronouncing that correct, Cleves, Ohio, appeared in the Hamilton County Court on Wednesday, facing 19 felony counts related to child sexual exploitation in a case prosecutors described as among the most disturbing they have encountered. Robert Shepard, we'll give him the presumption of innocence, is charged with one count of illegal use of a minor or impaired person in nudity-oriented materials or performance, and 18 counts of pandering, sexually oriented materials involving a minor. Hamilton County Common Pleas Court Judge Patrick Dinkenlacker set bond at $100,000 per count, resulting in a bond of $1.9 million. The judge characterized Mr. Shepard as a significant danger to public safety, but declined to elaborate further during the hearing. Now, the investigation began back in April of this year when the Hamilton County Sheriff's Office received a cyber tip from the National Center for the Missing and Exploited Children, also known as NCMEC. A subsequent search warrant executed on Shepard's electronic devices revealed extensive child sexual abuse material, including videos and images depicting infants and very young children. Now, during Wednesday's proceedings, Assistant Prosecutor Connie Pilch told the court that the content recovered represented just about the worst of the worst imaginable. She noted that the material involved real, identifiable victims, many of them babies, and emphasized that the severity extended beyond the specific files cited in the formal charges. Now, Shepard was arrested on November 10th. Prosecutors stated that following his arrest, 2 additional child victims from the local community came forward with allegations of direct abuse by the defendant. The prosecutor informed the judge that the separate investigation into those reports are now underway and stressed that Shepard had allegedly acted on his impulses against children in the area. The prosecutor expressed satisfaction with the substantial bond amount, describing Shepard as a menace to society. Speaking to reporters after the hearing, she urged parents and guardians in the community to remain vigilant and contact authorities if they suspect their children may have been had unsupervised contact with the defendant. Shepard is scheduled to return to court on December 9th, 2025 for further proceedings. And the police have issued a public advisory encouraging anyone with information about potential additional victims to contact the Hamilton County Sheriff's Office or the prosecuting attorney's office immediately. First, when I tell you, be careful with whom you let around your children, okay? How long do you think it takes for somebody to produce sexually exploited material with your children? Not long. So always know who is with your kids. All right? I told you, I did one of these cases just recently, literally 3 weeks ago, finished sentencing. Some of the worst type of cases that a defendant can have, some of the worst type of facts, and there's just never anything good about it because there are so many young victims. And in this story, we talk about how they want children, and you think, why do they want the children? And I swear to God, I've seen this in cases. These guys, sick individuals, literally say, you got to get them young so they have no memory of it. Okay? That's why these people do it. They are not mentally okay. They are predators on children. I'm not making this up, all right? Got a prosecutor telling you this. This is the worst of the worst. How many times do I warn you about people around your children? I'm not doing it because, I don't know, I'm doing it because I'm warning you. I live in this world where I see the worst of the worst. I see worse than anyone could possibly imagine. And I'm telling you, protect your kids at all costs. Next, a vigilante assault follows the release of a Brooklyn man who, went around spitting on white women. A 45-year-old man arrested for allegedly spitting in the faces of several white women in Williamsburg over a 2-day period was later subjected to a severe street beating by two unidentified assailants in an incident captured on video and then, it went viral online. Anthony Keynes was taken into custody by the New York Police Department on November 13th, following complaints of 3 separate assaults that occurred back on November 11th and 12th of this year. Court records describe the incident as close-range attacks in which Keynes approached unsuspecting women and spat directly into their faces. Prosecutors charged him with multiple counts of aggravated harassment, including allegations that the acts were motivated by the victim's race. One victim, who spoke on the condition of anonymity, described the experience as deeply disturbing, saying, quote, "I felt profoundly violated," end quote. "It happened suddenly in the morning while I was still half asleep. He walked up, spat, and continued on his way. I was left wondering whether I was simply expected to carry on with my day as if nothing had happened," end quote. Keynes entered a not guilty plea at his arraignment and was released the following day under supervised conditions, fitted with an electronic ankle monitor. Days later, a graphic 50-second video surfaced on social media showing a man identified by sources familiar with the case as Keynes being brutally attacked outside a Williamsburg hair salon. In the footage, 2 men dressed in dark clothing repeatedly punched, kicked, and stomped the victim while he lies curled on the sidewalk, attempting to protect himself. The assailants can be heard laughing during portions of the assault, and as the victim staggers to his feet, blood visibly streaming from his deep cut above his eye, the individual recorded the video issued a warning. "Stop violating these females out here. You're making us look bad." Keynes reportedly responded by noting that he had already been jailed, to which one attacker replied, "We're worse than jail," before delivering a final blow. Now, the NYPD confirmed to reporters that no formal complaint has been filed regarding the assault on Mr. Keynes, and investigators are aware of the video but have not announced any arrest in connection with that. Now, Keynes has a prior record that includes arrests for domestic violence and contempt of court, according to law enforcement sources. The Brooklyn District Attorney's Office continued to seek additional potential victims who may not yet have come forward. Obviously, drawn a little bit of attention to the broader pattern reported about the spitting incident. And, it's kind of, I'm not saying it's a good thing, but, sometimes neighborhoods need to take care of things themselves. Obviously, vigilante justice is wrong all the time, right? Although it is one way for people to conform with a little public urging. Next, this day in legal history, December 1st, 1865. Suspension of habeas corpus from the Civil War is repealed. That's right. Andrew Johnson ends the Civil War era suspension of the writ of habeas corpus that Congress had authorized in 1863. Now, the Habeas Corpus Suspension Act remained in effect through the war and was finally revoked in December 1st of 1865, restoring core constitutional safeguards in most of the country. On this date, December 1st, 1955, civil rights activist Rosa Parks was arrested for refusing to give up her seat to a white man on a bus in Montgomery, Alabama. Her actions prompted a year-long boycott of the Montgomery public transit system, which only came to an end after bus segregation was ruled illegal by the federal courts. On this date, December 1st, 1975, Hampton v. United States was argued. It had to do with entrapment and due process. On that same date, the court hears oral arguments in the case testing the limits of the entrapment defense and whether outrageous governmental conduct in a sting operation can violate due process even if the defendant was predisposed to commit the crime. Ladies and gentlemen, that's why most entrapment defenses fail because, well, usually the defendant is predisposed to commit the crime. They just wouldn't have done it if they'd known the other guy was a cop. And then on this date, December 1st, 2021, Dobbs v. Jackson's Women's Health Organization was argued. The Supreme Court hears oral argument in the Dobbs case, a challenge to Mississippi's 15-week abortion ban. Obviously, everybody recognized that the question from the justices signaled a possible overturning of Roe v. Wade, which the court ultimately does in June of 2022. Which sent that question back to the states. Remember, anything not specifically enumerated in the Constitution is reserved to the states. The Supreme Court said, not a federal question. Each state gets to decide what they want to do. Kind of like liquor laws, so to speak. You have dry counties somewhere, other places you can drink all day, anytime you want. I know it's kind of I wouldn't say stretch, but if it's not a federal issue, the states get to decide. Next, legal quote of the day. The safety of the people shall be the highest law. Marcus Cicero. The principle articulated by Cicero in his works underscored the foundational role of public welfare in the structure of just legal systems, reminding everybody that the ultimate purpose of the law is to safeguard society. Our dumb criminal of the day. In what police are calling the most technologically advanced snack run in local history, 33-year-old Cole Bertles of Illinois was arrested early Sunday morning after allegedly kicking in the glass door of a Circle K convenience store at 2:15 a.m. with one clear mission: liberate a bag of beef jerky and sweet tea from the cruel tyranny of the cash register. According to the probable cause affidavit, Bertles bypassed the store's sophisticated security system, namely a locked door, by introducing it to the bottom of his shoe. Once inside the darkened establishment, surveillance footage shows the suspect calmly selecting his targets, consuming the jerky on the spot and washing it down with an iced tea like a man who had walked 40 miles for brunch. When officers arrived, Bertles reportedly offered a full and frank confession, explaining that the voices in my head told me to kick it open since it was locked, before adding the bombshell clarification: I know you're going to think I'm crazy, but there's an AI intelligent speaker in my neck. Police have yet to confirm whether the alleged implant runs on Alexa, Siri, or custom beef jerky optimized firmware. Anyway, Bertles told the officers that he had walked the entire distance from Illinois because the public transit system apparently doesn't run at 2 a.m. And he now faces felony burglary, second-degree property damage, and theft of property valued under $150, an amount that in today's economy barely covers a decent bag of, well, jerky. A judge set bond at $2,500 cash and issued a no-contact order between Bertles and all Circle K locations nationwide. And if released, he has also been ordered to undergo a mental health evaluation, presumably to determine whether the voices are organic, artificial, or simply the result of, some low blood sugar. Court records show that Bertles was released on parole earlier this year after serving time for aggravated robbery in Illinois and has a lengthy resume of prior burglary convictions, making this the rare case where a man's criminal history and his late-night cravings appear to be in perfect alignment. As of press time, neither Amazon nor any major AI manufacturer has claimed responsibility for the next speaker. Circle K corporate headquarters declined to comment. Those sources say the chain is considering a new marketing slogan: open 24 hours. Please use the handle. All right, ladies and gentlemen, that's all we have for today. Thanks for watching. We'll see you next time on Crime Talk. And remember, go check out your merch, and the Constitution matters.